You are listening to Ethical Witness Preparation, a powerful witness preparation podcast mini-series from Holland & Knight attorney Dan Small. Dan is an experienced litigation attorney who has written books, published articles, and given talks around the United States on the ins and outs of witness preparation. In this 5-part series, he addresses the main ethical issues that arise during witness preparation and explains how lawyers can successfully navigate these issues while setting their witnesses up for success.
There are few areas in the law that present as many ethical challenges as witness preparation. On the one hand, a lawyer has a duty to prepare a witness, and the witness needs our help. On the other hand, witness preparation is very difficult to do, both ethically and effectively. In this 5-part mini-series, we'll address some of the main ethical issues that arise in witness preparation. We'll cover the extreme case of perjured testimony, the 4 horsemen of the lying witness apocalypse, the Massachusetts example of approaching perjured testimony, preparation versus improper coaching, and ethical conduct in the deposition room. Let's start with the extreme case of perjured testimony. As the Supreme Court said long ago, all perjured relevant testimony is at war with justice, since it may produce a judgment not resting on truth. For counsel, the dilemma arises when this search for truth conflicts with our dual obligations to represent our client zealously while carefully protecting the attorney-client privilege. There is no easy way out. Consider the case of In Re Attorney Discipline, 98 F. 3rd, 1082. The basic facts are simple. A divorce trial is underway, and the custody of the young daughter is at issue. The husband's lawyer calls a surprise witness, a man who testifies that he had an affair with the wife. He says they met at a local motel, and sometimes, when the wife was unable or unwilling to find a babysitter, she brought the 18-month-old daughter to the motel with her. He says that she would place the daughter on one bed while they consummated their affair on the other bed. Worse still, if the child became fussy, he said they'd give her a bottle of beer to keep her occupied. The testimony concludes, a recess is called, and the wife's lawyer is left wondering where the truck came from that just ran over his carefully prepared case. How would he react to such devastating testimony? How would you react? The court reporter had a tape recorder backup system that was accidentally left running during the recess. Alone in the courtroom, the wife and the lawyer had this exchange. Lawyer: what about this business about the motel? Did that happen? Client: yeah, it happened. Lawyer: you better deny this. 18 months old. Jesus, you better deny this. Client: well, what can I do with it that won't make it seem like I'm lying? Lawyer: if you said it didn't happen, it didn't happen. Having heard his client clearly admit that the testimony was true, after the recess, the lawyer calls her to the stand, and with great outrage he asks, under oath now, do you ever remember going to a motel with your daughter? No, she answers. That's a lie what he says, isn't it? Yes, she answers. The tape recording eventually came out. The lawyer was disbarred, and the Eighth Circuit upheld his disbarment. It would be tempting to dismiss this case as too extreme, but that would be wrong. First, under the great pressures of a trial, we hoped that we would all be angels and do the right thing. But most of us are humans, not angels, and we can understand the shock that lawyer must have felt, along with the temptation to just make it go away. Second, we have to understand that we all tell our clients to lie in ways far more subtle than, you better deny this, you better deny this. How? By not understanding their preconceptions about lawyers and what we want. By not listening carefully enough to the client and their competing pressures and beliefs. By not appreciating that what may be just another case to you may be one of the scariest and most significant events in the witness's life. And by not taking the time to help them understand the case, the process, and the rules. So how do we deal with the situation of the lying witness? It would be great if there was a simple answer. Sadly, though, the competing obligations create a dilemma where there is no good answer, just an ongoing search for the best route to safety and to truth. Clearly, you better deny it is not that route. Throughout this 5-part series, we'll explore some of the potential paths for ethical witness preparation.
Thank you for listening to Ethical Witness Preparation, a podcast series brought to you by Holland & Knight attorney Dan Small. To learn about Dan and his practice, please visit hklaw.com/Daniel-Small.